that was part of your consideration for.
Oh, I see.
Apology.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDow is being held on a $50,000 bond. This is the result of an emergency bond motion.
A mother being held on a $50,000 bond is asking the court to release her. But prosecutors say the allegations involve a violent attack against her own 15-year-old daughter. According to the prosecution, Jaleesa McDow allegedly stabbed the teenager with a butter knife severely enough to require stitches and threatened to kill her. The daughter was reportedly so frightened that she texted a friend to contact police. McDow denies causing the injury, while her attorney argues that the case has not yet been tested through a substantive hearing and that important circumstances have changed since the bond was imposed. The children are now living with their grandmother in Detroit, away from McDow's home, and McDow offers to wear a GPS tether and obey strict no-contact conditions. She has already spent 15 days in custody, fears losing the supervisory job she has held for more than 5 years, and says her home may be vulnerable to vandalism or intrusion while she remains jailed. But prosecutors reveal a prior domestic violence conviction and another pending domestic-related matter. Will the judge view GPS monitoring and physical separation as sufficient protection, or decide that the alleged violence and criminal history make release too dangerous?
Let's call the case People versus Jaleesa McDow.
Alexander on behalf of the people, Your Honor. Asli Bashir on behalf of Jaleesa McDowell.
Jaleesa McDow.
And Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address bond before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that for case, there's a case out of 14A2, 25203, or, oh, sorry. Okay, actually, no, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I...
Out of my court?
Oh, sorry, 14.8.2.
So what would you want me to do with that?
Well, in case that was part of your consideration for...
Oh, I see.
Apology.
You don't want me to change it.
No, I do. Oh, so as far as this matters... Yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
We have screenshots.
Yeah. And we do, we are gathering discovery on the matter. And I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
Got her move.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. Her She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her...
Where are the other two children?
My kids were left at home, attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home, attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with their grandmother.
I got to move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just...
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir. And that is taken care of. And it was just you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds, and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all.
The defense has now presented its strongest argument for reducing the bond. McDow has spent 15 days in custody, offers to submit to GPS monitoring, says she has not attempted to contact the complaining witness, and emphasizes the financial pressure created by her detention. Her attorney also argues that the most important safety circumstance has changed. The daughter and the other children are now living with their grandmother in Detroit rather than next door to McDow. But this is a bond hearing, not a trial. The judge is not deciding whether McDow is guilty beyond a reasonable doubt. The court is assessing risks such as public safety, potential contact with the complaining witness, appearance in court, and compliance with release conditions. McDow's emotional statements about her children and employment may demonstrate hardship, but they also risk introducing disputed facts before her attorney can properly frame them. The prosecution will now argue that relocation does not erase the underlying allegations or McDow's prior record. Should physical separation and GPS monitoring justify release, or are the alleged threats too serious for those safeguards?
Your Honor.
Your Honor, the court's familiar with this case. I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since the last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was $100,000, so I believe $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe. I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider.
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an act.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
And I did also make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I have concerns that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
The judge ultimately denied McDowell's request for a bond reduction, leaving the $50,000 bond in place. The defense argued that the children had relocated to their grandmother's home in Detroit. McDowell was willing to wear a GPS tether, and there were no allegations that she had attempted to contact the complaining witness while in custody. Counsel also emphasized her 15 days in jail, employment history, housing concerns, and the fact that the allegations in the police report had not yet been tested on their merits. The prosecution responded that the underlying accusations remained unchanged. McDow allegedly injured her 15-year-old daughter with a butter knife, causing a wound that required stitches, and allegedly threatened to kill her. The state also corrected the defense's suggestion that McDow lacked a violent history, identifying a 2018 domestic violence conviction, a 2020 larceny conviction, and another pending case involving a domestic relationship. The ruling does not establish guilt. It means the court was not persuaded that changed circumstances justified lowering the existing bond. Did the judge make the right public safety decision? Or could GPS monitoring and strict no-contact conditions have adequately protected the daughter? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.